designed to cover a particular area of expertise. The first item, which is paragraph 15, simply gives my position at Queen's and talks about my research interests, which are in the area of public finance with special emphasis on tax policy, cost benefit analysis, and fiscal federalism. And it also talks a little bit about the work that I've done in natural resource taxation that would be relevant for this case, involving both the taxation of renewable and non-renewable resources, the taxation of businesses with a view to designing a business tax so that it applies to rents, and the evaluation of investment projects by using present value techniques.
What is the chair itself? What's involved with that?
I hold a named chair called the David Chadwick Smith Chair. And chairs are positions at universities that are funded by a donor who wants to have a name associated with a position. So the David Chadwick Smith Chair is a chair that was named after a former principal of Queen's University who had an interest in economic policy. And so this chair was set up to fund a position for some scholar to study Canadian economic policy. And it now has emeritus attached to the end of it because I'm retired.
In paragraph 16, you address a number of textbooks that you've written, survey articles as well, and monographs. First of all, for those of us who might not know, what is a monograph?
A monograph is something between a book and a journal article. It's usually of the order of 100 or so pages, and it tackles a particular topic in a way in more depth than could be done in a journal article. Like a journal article, it's a peer-reviewed publication, but it gives the researcher an opportunity to go a little bit deeper into a particular topic.
So as you say here, you've written a number of textbooks, survey articles, and monographs. Can you then elaborate on that for us, please? You view these as relevant to this litigation, obviously, by what you say here in paragraph 16.
I've written textbooks in the area of public finance that are broadly relevant for the economics underlying this case. I've written a monograph on mining taxation in Canada. I've written a monograph on transfers between levels of government in Canada called fiscal federalism. And I've written monographs on areas of tax policy more generally and business taxation.
In the next paragraph, paragraph 17, you address your undergraduate and graduate teaching courses in public finance, amongst other things. Can you go through that, please?
What you find in paragraph 17 is a summary of the places that I've taught. My main teaching position is at Queen's University and has been for decades, shall we say. But I, like most academic positions, you take some time off for a year to go and take a sabbatical or teach elsewhere. So I've done teaching elsewhere for a year, University of Chicago 1 year, Catholic University of Louvain another year. And as well, I've done quite a number of short courses, 3 or 4 week courses, invited courses at universities around the world that are intended to bring students, graduate students in other countries, I should say, up to scratch in modern public finance theory. So I've just listed a number of the universities there that span Norway, Spain, China, and the United States, and as well Japan and Luxembourg.
And then you next move on and talk about reports you've prepared for various commissions. I understand, I'm skipping ahead a little bit, you have testified before parliamentary committees.
Yes, yes.
On how many occasions, roughly?
I've testified at mostly federal level parliamentary committees, both the House of Commons and the Senate. I haven't kept track of the number, but there must be 7 or 8, I suppose, on different topics related to mostly tax policy, but also intergovernmental affairs.
Thank you. So then tell us what you'd like us to know from paragraph 18 here, please.
Paragraph 18 just indicates the kinds of royal commissions that I've been asked to prepare papers for. The first one you may or may not be familiar with, it's the Royal Commission on the Economic Union and Development Prospects for Canada, popularly known as the Macdonald Royal Commission, whose main achievement was to argue for and succeed in getting a free trade agreement with the US. Then there are other royal commissions in Canada and elsewhere. Perhaps I should draw particular attention to the Royal Commission on Aboriginal People. I was invited to prepare a paper on the financing of what was then called Aboriginal self-government. And I've also done invited projects for international organizations, such as the World Bank, the International Monetary Fund, the Organization of Economic Cooperation and Development, as well as research or policy institutes within particular countries, especially developing countries. I spent some time at the Financial and Fiscal Commission in South Africa, talking about federal-provincial relations, South Africa being a federation. And I also spent some time at the Finance Commission in India, dealing with the reform of their equalization system.
In paragraph 19, Professor, you address your various roles as editor.
Paragraph 19 is just a short statement of the journals that I've edited over my career. I was the editor of the Canadian Journal of Economics, which is the journal of the Canadian Economics Association. I was the editor of the Journal of Public Economics, which is the sort of top journal in public finance internationally. And I was the editor of the German Economic Journal, which is the journal of the German Economics Association, as well as being an editor of a series of monographs that is published by Cambridge University Press on public economics.
In the next paragraph, you discuss some honors you've received for your work. And I appreciate it can be difficult to address that kind of thing, but I would like you to do that, please.
Well, I have just put into paragraph 20, whether or not it's relevant for this, I'm not sure, but just as an indication of stature, I've put in some of the awards that I've won over my career. I listed an officer of the Order of Canada, a fellow of the Royal Society of Canada, a fellow of the Canadian Economics Association, and a distinguished fellow at the University of Munich. And I also list some of the professional jobs I did for international organizations, such as the president of the Canadian Economics Association and something called the International Institute of Public Finance, which is an international organization of scholars who study public finance around the world.
And can you give us a quick and dirty on public finance, your view of what public finance is?
Broadly speaking, public finance is the study of the role of government in the economy, what its role is, evaluating policies it undertakes, suggesting policy reforms that it might undertake. And then I would just make one important distinction that comes up in public finance, and that is a distinction between positive and normative analysis. Positive analysis studies empirically what is observed in society, the consequences of policy. Normative public economics studies the desirable changes that governments should institute. So one can imagine in a case like this that one has to combine positive analysis of what's actually happened with normative analysis of what you think would be a way forward in future.
In paragraph 21, Professor, you mentioned a number of research projects that you think have bearing to this case. Can you take us through that, please?
The main ones would be in areas of natural resource taxation. I've done a number of studies of the taxation of mining in Canada. I've done studies of the effect of oil and gas industry as it spills over to the rest of the country, and industries in the rest of the country. I've done major studies on best practices in natural resource taxation, covering both non-renewable resources like mining and renewable resources like forestry or fish. And these monographs are, as I say, attempts to apply the lessons that we've learned in different countries to not only to Canada, but to other countries around the world in terms of designing a natural resource tax which most efficiently extracts revenues from those industries. And I think to bring it closer to what we're talking about in this case, it studies in particular the way to design taxes to extract rents from natural resources. So there's sort of two major impacts. One is the design of taxes to extract rents, and the other is a sort of macro approach of how natural resource industries affect the development of the economy, in particularly how they influence, how their activities influence or spill over to other areas of the economy, such as manufacturing and high-tech industries.
I'm just going to catch up for a moment, please. Thank you.
In paragraph 22, I quote the first sentence. I've studied the lessons that may be drawn from fiscal federalism for the financing of Aboriginal governments. Can you just take us through this paragraph? And you return, I see, to the Royal Commission on Aboriginal peoples.
I emphasize here two projects that I was involved in. One was a research project that was done for the Royal Commission on Aboriginal peoples, which, as I mentioned earlier, was a study of mechanism for financing self-government. And the idea here is to draw on what we've learned in the analysis of federations and how federations finance subnational levels of government through grants and equalization and so on. See what lessons can be drawn from that for the financing of First Nation self-government. And as well, I prepared a somewhat similar report, I would say, for the government of Yukon as part of the negotiations that took place between Canada or among Canada, Yukon First Nations and the government of Yukon to achieve an agreement on a comprehensive land claim, part of which was financial aspects, transfer of funds and revenue raising and so on.
Turning to paragraph 23 of Exhibit 62. This is the final paragraph I'm going to have you address in this exhibit, Professor. You already talked about appearances before the parliamentary committees of one sort or another. And you mentioned here expert evidence in court cases. Can you just tell us about that, please?
Well, I've really only given expert evidence in one court case, apart from the parliamentary ones, which were not the same, but the court case that I appeared for was as an expert witness for Canada in a constitutional case involving the spending power. The particular issue was whether it was constitutional for the federal government to use income tax revenues to fund transfers to governments for the support of particular health programs, given that health was an area of provincial jurisdiction. So it was precisely a spending power issue.
Thank you. If we could now get your updated curriculum vitae up front, please. You prepared this document
I did.
and it fairly reflects your career endeavors and background as far as
Yeah.
you're concerned.
Academic background, yes.
May we mark that, Your Honor?
Any problems?
No.
Thank you very much. As the next numbered exhibit, do we have? Exhibit 72 and curriculum vitae of Robin Boadway.
Now, Professor, you have considered, in the interest of time, because there is such an extensive body of work referred to in your CV, you have considered work reflected in the CV that you think may have particular relevance to the matters in issue in this case, correct?
Yes.
Before we get to that, I just want to note very quickly, you got an undergraduate degree from the Royal Military College in chemical engineering, right?
Yes.
And then 2 degrees from Oxford.
Yes.
And the second of those is what exactly?
It's a degree that's unique to Oxford and UK, I guess, at the time that I took it. Excuse me, it refers to a Bachelor of Philosophy, but you can think of it as being the analog of an MA degree here.
Okay. And then your PhD from Queen's.
Yes,
And going down to honors, you received a Rhodes Scholarship in 1964.
yes.
Right. Let's then move to page 2 into the publications section. And I will ask you to take us through, having considered this in advance, the publications you consider to have relevance to the matters in issue in this case.
Well, I've selected a number of, probably too many, but I've selected a few publications that are most closely relative to the work in this case. One of them is on page 2, entitled Taxes on Capital Income in Canada, Analysis and Policy. Co-authored with Neil Bruce and Jack Mintz. This was a monograph, use that terminology, that evaluated the state of taxes on capital income in Canada back in the late 1980s and made proposals for reform. And the reason I would include this paper in here is because the taxation of capital income has many similarities to the taxation of natural resources. Both of them aim to extract revenues on rents generated by productive activity.
This is right at the bottom almost of page 2.
Yes,
correct?
yes,
Anything else on page 2?
no. Well, there are other things, but not directly relevant to.
Thank you. How about going over to page 3?
I would say that the very first item on page 3 is relevant, and it's related to what I had just mentioned, is another monograph on federal and provincial taxation of the mining industries, impact and implications for reform. This study was particularly focused on how efficient the mining tax system was in Canada, given that mining taxation was quite complicated. it included both federal and provincial taxes on mining corporations, as well as provincial mining taxes. The only other thing on that page that might be of relevance is one called Canadian Tax Policy, which was a textbook on the Canadian tax system that covered not just business, capital, and resource taxation, but also personal property taxation, sales taxation, and so on. So it was sort of an overview of the tax system with respect to how well coordinated it was and how the parts fit together.
And this is the last item on the page, is it?
On page, it's called Canadian Tax Policy. In
Oh, it's
middle
the end of
page
the first
3.
paragraph, end of the first paragraph, I see, sorry. Yep.
Moving on to page 6 of the CV, there are 2 or 3 papers there that deal with the taxation of capital and mining. One is called Marginal Effective Tax Rates for Capital in the Canadian Mining Industry. And it's an evaluation of the disincentive effects or the incentive effects that exist in the Canadian tax system, including both corporate and mining taxes, on the incentive of firms to explore, extract, and process minerals in Canada. It wasn't specific to Ontario. It was a study that looked at all provinces. And just above that, there's a rather esoteric title of a paper called A General Proposition on the Design of a Neutral Business Tax, which means in layman's terms, it refers to a proposal for designing business taxation, whether it's corporate taxation or mining taxation, in a feasible way, administratively feasible way, so that the tax would be, as economists would say, efficient or non-distorting. Or to put it in slightly different terms, the tax would apply only to the rents of the business that was liable for it.
Sorry, could you tell me again where that one is? You said just above the
This
article
one is
marginal effect.
I'm sorry, Your Honor, it's in the middle of page 6,
Yes,
and it's called A General Proposition on.
Got it.
Yeah,
thank you.
sorry. I won't do too many more, but there are a couple that are more directly relevant for our proceedings. On page 12, the very first item on page 12 is a journal article called Tax Policy for a Rent-Rich Economy. And the idea of this paper is to say that a lot of the income that individuals and corporations receive has a rent component to it, whereby rent, I mean, not just the kind of rents we're talking about in this case that are earned on natural resources, but also refers to sort of unexpected gains or windfall gains that people get simply because of luck, let's say. So, for example, one would include in this category inheritances. You can think of inheritances from the point of view of the inheritor as a windfall gain, a source of income that they didn't do anything to generate. And then there's another one midway down called Natural Resource Extraction in a Federation. And this is a paper that deals with the consequences of natural resource extraction for manufacturing industries in an economy where you've got resources and manufacturing competing for capital and investment. And the spillover effects that occur. And so just maybe a couple more. Page 14. I mentioned this one because it's something that comes up in our one of our expert reports, is a paper called The Dutch Disease and the Canadian Economy, Challenges for Policymakers. This is a paper that evaluates the consequences of particularly oil and gas extraction in Western Canada, how that spills over into industries elsewhere in Canada, particularly manufacturing industries. And the spillovers take two effects. For one sort of spillover is the fact that natural resource industries face very volatile prices, and the volatility of those prices causes the exchange rate to become volatile, which in turn causes manufacturing.
Could you slow down?
prices to
I'm
be-
sorry, could you slow down just a little bit, please?
Sorry, yeah,
I see the
I was
keyboard
getting-
smoking.
getting too volatile there.
So back that up again, would you please? I'm sorry.
All I meant to say is that this is a study of how natural oil and gas activity in the West spills over onto manufacturing industries elsewhere in Canada. And the spillovers partly take the form of spillovers of volatility through the exchange rate, which causes manufacturing prices to go up and down as well. And the other source of volatility, the other spillover effect is the fact that resources are drawn into the oil and gas industry that could otherwise be used in manufacturing or other secondary industries. So that paper I highlight because it uses the term Dutch disease, which appears in one of our reports. And finally, I don't want to spend too much time on this, but on page 17, there are a couple of pieces that might be considered relevant. One is called, sort of third of the way down, rent taxes and royalties in designing fiscal regimes for non-renewable resources. So non-renewable resources are resources like minerals, as opposed to renewable resources, which are resources like forestry. This is a monograph style paper that, as I mentioned earlier, looks at best practices around the world for designing rent taxes on minerals that extract rents in an efficient way. And finally, there's another one called drilling down. It's sort of refers drilling down on royalties, how Canadian provinces can improve non-renewable resource taxes. Again, this has to do with non-renewable resources, and it focuses particularly on the oil and gas industry, although similar principles would apply to mining. And the idea here is partly to sort of say, well, we're not designing our taxes on non-renewable resources, in particular oil and gas, in the most efficient way. We're not designing them to be proper rent taxes. Here's how we could do better. And it draws a little bit of comparison with practices elsewhere. That's probably as much as I need to say, if not more.
Thank you. Let's turn to your demonstratives, please. Who prepared these?
I prepared this.
On slide 2, if we could.
Thank you.
On slide 2, you set out reports prepared with Professor Smart. I believe these have all been entered as exhibits already, so I don't think that we need to do anything more on this slide.
The only thing I would draw your attention to, if I may, is that I've taken the opportunity to insert after each title how we would refer to them in the rest of the demonstratives.
Very helpful. Thank you. Thank you. Oh,
Perhaps my friend had wanted to have the expert qualification statement entered as an exhibit and have
and-
the expert qualified. I think he
and the
I thought we
proffering.
missed it.
Yeah. I
you
thought-
said you're going to do it, but
Oh, well, I did proffer him. I thought you accepted him. You didn't accept? Okay. Thought I addressed that right at the end of the agreement. Can we mark that agreement then, and I'll proffer the professor in accordance with its terms?
thank you very much. And I'd like to mark this expert qualification agreement as
73, I guess.
Exhibit 73. Thank you. So Exhibit 73 is the qualification of Professor Boadway on consent. And Professor Boadway is now qualified to give opinions within the terms of the agreed qualification. Thank you very much.
So I think we can go to slide number 4. And maybe you can just take us through
Oh,
that.
one
please.
more thing. Usually what we do at qualifications, Mr. Marcello, waiver of copyright.
Do you waive copyright on your reports?
I do.
Thank you very much.
So on slide number 4, you address the scope of your testimony.
Right. You passed over slide number 3, which sort of set out the rationale
I
for
did.
the scope of my
We can
testimony.
go back to that if you'd like.
I mean, it's not, I think it's kind of important because I want to repeat something that Professor Smart, I think, already indicated, and that is the division of labor in preparing these reports. That Professor Smart was responsible for doing all the data work and the calculations and the estimations. And I was involved in other aspects of the report, formulating the ideas, writing the reports and so on. Although all 5 reports are accepted by both of us. So in his presentation, he focused on things that he was primarily responsible for, which was our methodology for estimating NCRRs, the alternative approaches to sharing them, including by risk adjustment, converting them to annuities and calculating a present value. He did address differences with the plaintiff's experts, in particular, Mr. Hutchings, in details of measuring Crown resource revenues and resource-related expenses. So my focus will be, I've been assigned the task of responding to the reports prepared by Professor Stiglitz and Mr. Hutchings, including especially their use and measurement of total rents, their approach to sharing, the interest rate that they use for bringing forward NCRRs, and their wealth deprivation, or perhaps a better terminology is their relative wealth analysis.
And if we go over to slide 4, you address with more particularity there what it is you intend to do. Is that right?
Yes.
Can you just tell us about that, please?
I have listed in slide 4 the parts of the reports and demonstratives of Professor Stiglitz and Mr. Hutchings prepared for the Robertson Superior Treaty. I put that in explicitly and then in brackets put RST because whenever I use RST, I simply mean the acronym for Robertson Superior Treaty, nothing more. If I want to talk about the Robertson Superior Treaty members, I'll append members to the end of it. So I've listed the reports that I'm responding to. And again, in quotation marks, I've indicated how I'll refer to these reports and what follows.
Now, those of us involved with the case all know that new reports were delivered in January of this year. Can you just address how your reports line up with the revised reports we received in January? In other words, no new reports were done following the ones we received in January. You did not do any new reports. There were redactions made, and there are comments in the earlier reports that I believe generalized, but I'd like you to just elaborate on that a little bit for Her Honor.
Our three main reports, our so-called nominal values report, our present values report, and our response to Professor Stiglitz and Mr. Hutchings, were delivered at the end of June of 2022. And they were based on reports that were originally done by the plaintiff's experts. And these reports, some of them were reports that were done for RHT. For example, the original Stiglitz-Hutchings report was done for the RHT. And some of them were done jointly for RHT and RST. I think it's fair to say. I may be wrong about that. In any case, most of the, well, apart from the numbers, the commentary that we made on the reports of the plaintiff's experts still stand, because when they changed when reports were changed from RHT reports, for example, to RST reports, the substance, economic substance of the reports was very similar. Only the numbers had changed. So our response to those reports equally applied to their new reports, except for the particulars of the numbers. I hope I've been clear in saying that. In fact, it was a little bit more complicated than that, because the first set of redactions that we did had to do with redactions occasioned by the unfortunate withdrawal of one of the expert witnesses for RHT. And part of our report had addressed an aspect that this expert witness had emphasized in his report. So we had to redact reference to that kind of discussion. I mean, I can be more explicit if you want. But
And this is Professor Beal we're speaking of?
yes. And I mean, maybe should I be more explicit about the kind of things we had to worry about?
I'll let Mr. Marcello direct you.
I don't think that's
No, okay.
necessary. Is there anything else you want to say about the evolution of the reports, as it were?
No, it was all new to me, this process of redacting and so on. So.
But your point is the substantive economic comments remain.
Yes, yes.
So on slide 4, you, as I said, address with some particularity what it is you're going to do, and it speaks for itself. I don't think that unless Her Honor wants that we need to go through that. And if you go over to slide 5, again, I don't know that this requires a lot of time, because it's quite transparently produced in the reports. There are the instructions you received from Counsel for Ontario, some of which are set out on slide 5, correct?
Yes. These are the parts of the instructions that are relevant for my demonstratives. Other parts of the instructions had to do with measuring NCRRs, which Professor Smart dealt with.
Now, if we move to slide 6, again, you return to your responsibility or what you're going to address in this case. I will ask you to go through this, please.
Okay, my task that Professor Smart and I jointly agreed to was to first of all, respond to the Stiglitz-Hutchings RST report. Now I'm using those definitions of the reports that I set out
Thank you.
early on. Secondly, I'm going to present two elements of our present value report that deal with responses to the plaintiff's experts. One is section 7.3 on what I've written as wealth disparities, but which is sometimes referred to as relative wealth differences by the plaintiffs. And section 8 on the choice of interest rate for bringing forward NCRRs to the present, the relevance of stock market returns as a component of the bring forward rate, and economic approaches to sharing NCRRs. Not just, well, I'll leave it at that for now. And third, I will have some remarks about this from our SIR reply to the Stiglitz and Hutchings RST reply reports. The paragraph at the bottom simply reiterates what we were talking about earlier about the fact that our initial reports were written in response to reports by Professor Stiglitz and Mr. Hutchings on the RHT and their reply report. These were changed to RST reports, and as a matter of fact, much of the language in those reports is basically identical. What's changed mainly are the numbers. So my report, my comments will address what became their RST reports and not the RHT reports.
So which report, if you could just name the reports that were redacted to reflect, or were they all redacted to reflect the change to RST only? Present value and nominal value.
Slide 4 might assist with that.
Or-
Every one of the
In fact, I'd prefer to go to slide 2 if we could.
but I was going to suggest that's where we're in slide 2. You have a list of the 5 reports that Professor Smart and I and myself jointly prepared for the government of Ontario.
Right?
Every one of those reports has been redacted. In some cases, the redaction only involved redacting Professor Beale's reference to Professor Beale. In the others, the redaction involved redactions that arose because of the withdrawal of the RHT from the case.
You use the word revised on the slide. Do you use revised and redacted interchangeably?
Yes, I do, Your Honor. That's an important distinction.
Or an important non-distinction? But that you're saying that your use of the word revised on the slide means redaction to you.
Yes, yes, but what I mean when I say that it's an important distinction is that the revision consisted of the redaction. I hope I'm right when I say this, and not a rewriting of the material.
That's what I
should be
understood.
careful.
Thank you.
My memory is not always.
All right, so let's go to slide number 7. And tell us what it is you're going to address.
Okay, I thought it would be useful to outline the organization of my presentation. And in this slide, it shows that my presentation is divided into 7 parts, each of which are dealt with sequentially in the demonstrative. The first part is a kind of a background piece that is a summary of the Stiglitz and Hutchings approach to rents, to sharing of rents, to discounting, or more accurately, bringing forward those rents to 2022, 2020 present values, and to wealth deprivation or relative wealth differences. So I summarize what Stiglitz and Hutchings say about those things, and then I outline very briefly what we find, Professor Smart and myself find to be shortcomings of that approach, which will form the substance of the remainder of my testimony. Now, the second point is one that is a bit professorial, I'm afraid.
We're getting used to it.
Throughout my testimony, something that's going to come up many different times, as I'm sure Your Honor is well aware, is the notion of risk and how to deal with it. In particular, what do we mean by the cost of risk? When do we have to take it into account? When do we not have to take it into account? And my sense, I have to admit that I listened to some of these proceedings online before I came here, but my sense is that not everybody's on the same page with respect to the interpretation, the meaning of the cost of risk and its implication for various aspects of this case. So what I've taken the liberty of doing is preparing a few slides on what I'll call a primer on the cost of risk, which attempts to provide an exposition in one place of what I think are the most important things to take away from the cost of risk for the purposes of different parts of the testimony to follow. So I ask for indulgence on this because this is material that although it was in our original reports, it wasn't there in any single place. So I sort of brought together in as simple a way as I could my explanation of what the cost of risk is and what its relevance is. So then the next 5 sections all deal with responses that I have to the Stiglitz and Hutchings approach and or the Hutchings RST approach, beginning with the fundamental thing about what is the relevance of net resource rents for the RST augmentation promise. And I'm going to define net resource rents. I'm going to use that as the terminology to refer to what Professor Stiglitz and Mr. Hutchings call rents net of Crown related resource expenses, words to that effect. Then I'm going to turn to a series of what I think to be difficulties in measuring and taxing natural resource rents, which are important because they have an influence on how we should use the concept of net resource rents and to what extent we should use net resource rents that we can't measure or we can't tax. The next step is, again, probably one of the more controversial ones. Well, I wouldn't say that. It's a controversial one. And it has to do with what is the appropriate interest rate to use to bring forward NCRRs or annuities, payments to the RST and Shinabek, to bring them forward to the present day so that we know what is the value of the thing we're considering there, the augmentation promise. And I'm going to focus particularly on the one that is preferred by Professor Stiglitz and Mr. Hutchings, which is a rate of return, which is the expected rate of return on a portfolio of assets consisting of 60% stocks and 40% government bonds. That is the rate of return that they use to bring forward NCRRs to the present. As opposed to simply using the risk-free rate of return, for which we proxy the government long-term bond rate. So the difference between these two things is essentially the fact that part of what Professor Stiglitz and Mr. Hutchings are doing is including the extra return that one expects to get on equity in their discount rate. And I'm going to talk about the pros and cons of doing that. Then I'll turn to, again, another important topic, which is the appropriate way of sharing resource rents. And I'm going to contrast the views of Professor Stiglitz and Mr. Hutchings with our own view. And our own view, we have a preferred view, which you probably have heard about undoubtedly have heard about from Professor Smart. But in the process of doing our analysis, we actually present alternative views, of which we have a preferred one. And then finally, I'm going to talk relatively briefly about wealth deprivation analysis. And again, I've said this several times. I should have referred to this as relative wealth analysis because that's the way that it appears in the instructions that were given to Professor Stiglitz and Mr. Hutchings. Okay, so that's the outline of my testimony. At the bottom, it just indicates at the bottom which points refer primarily to the Stiglitz-Hutchings RST report and which points are common to both the Stiglitz-Hutchings report and the Hutchings report. Because Mr. Hutchings follows, even though he doesn't use the concept of net resource rents like Stiglitz and Hutchings do, he still brings them forward. He still uses the same sharing approach. He still uses the same wealth deprivation analysis. He still uses the same interest rate for bringing forward his share of the NCRRs to the present. So
The same as,
Professor Stiglitz, Mr. Hutchings in his RST report uses the same interest rate to bring forward NCRRs as Professor Stiglitz and Mr. Hutchings do them together when they bring forward total rents.
thank you.
You're referring to the 60-40 model in part there? are you?
Yes, I'll refer to that as the 60-40 model. It's a
Right, with that, Professor, let's go to slide 8, which is the introduction to the first part of your testimony and move on from there.
this section is simply building context. It's sort of pointing out, it's summarizing for everybody what the main points of the Stiglitz-Hutchings approach are. And it's going to finish by saying, here are the concerns I have with that approach. So if you will go to the next
Slide
slide,
9.
please. The Stiglitz and Hutchings RST report is a very long report. There's a lot in it. It's a very well written report. There's much to digest. But for our purposes, there are a limited number of very key things that are important that contrast with the way in which we address these issues. So let me give a caricature of what the Stiglitz-Hutchings RST report does. First of all, it estimates the value of resources in the RST territory, using as a measure total resource rents net of Crown resource expenses. And I'm going to hereafter refer to that measure as net resource rents. So net resource rents, and I think it's a fairly unambiguous concept. Then, I'm not sure if they go exactly in the same order that I'm setting it out here, but logically, the next thing they do is consider alternative frameworks for sharing these net resource rents with the RST beneficiaries. And they consider 2 or 3 different approaches to sharing, which I shall characterize as a cooperative bargaining approach. That's an economics term, but it essentially means bargaining between the two sides of the treaty makers over a share of the net resource rents that should go to the Crown as opposed to going to the Anishinaabe. And the other approach they take is not a bargaining approach, but it ends up with a somewhat similar outcome. It's called a shared risk approach, where, or more alternatively, a joint venture approach, where the notion is that the treaty is like a joint venture where both sides contribute something and maintain that contribution in an ongoing way, and that leads to some sort of sharing. The Stiglitz and Hutchings RST report advocates for the shared risk or joint venture approach to sharing net resource rents. Although they talk about bargaining approaches, they don't use them in their subsequent analysis. They primarily rely on the joint venture approach. And in that approach, they argue that the RST beneficiaries' share should be 84%. So having then
84% of what?
84% of net resource rents.
Thank you.
I'm talking about the Stiglitz and Hutchings RST report now. In the Hutchings RST report, he also adopts this shared risk or joint venture approach and attributes 84% of net Crown resource revenues rather than net resource rents to the RST beneficiaries. So then the report calculates 2021 present values of these annual shares of net resource rents. They bring these annual shares up to the present using the 60-40 market portfolio expected rate of return. But this rate of interest is not a rate of interest, it's an expected rate of return that you would expect to get if you invested your money into this kind of a portfolio. You're not necessarily guaranteed to get that. You may get more or less depending upon how the risk works itself out. And then the final thing they do is they provide estimates of wealth deprivation using a so-called income gap framework. And I'll come back to the explanation of that later.
As we move to the next slide, number 10, you continue your discussion of how Stiglitz and Hutchings treat net resource rents.
This slide is simply the bottom line of the procedure that the Stiglitz and Hutchings RST report undertakes that I just explained. So just for context, and I'm sure you're familiar with this, Your Honor, from previous testimony, but just for context and to have this in one place, I'll just summarize what the bottom line is for the calculations that the Stiglitz and Hutchings RST report did, not including the last bullet about wealth deprivation, I should say. They estimate the 2020 present value of total resource rents, not net resource rents, total resource rents from the RST territory to be $162 billion using 60-40 market portfolio interest rates. That is the value of all of the annual estimations of total resource rents brought forward to 2020 using a market portfolio compound interest rate.
Now I'm just going to ask you to slow down
Yep.
for 1 second. Thank you. Go ahead.
Professor, had you finished speaking to the first bullet on slide 10?
Yes, I have.
Thank you.
So the second bullet, it says that this is reduced by the present value of Crown resource expenses estimated by Professor Stiglitz and Mr. Hutchings to give a total present value of net resource rents of $126.3 billion. This represents the amount to be shared. As they say explicitly, this is the amount to be shared with the RST beneficiaries assumed to be entitled to 84% of the present value of net resource rents, which amounts to $106 billion. So that is the bottom line in amount that would satisfy, according to them, the augmentation promise.
That's bullet 3.
That's bullet 3. And then bullet 4, I simply report, as they do, that if instead of using the 60/40 market portfolio interest rates to bring forward these net resource rents, if we had used the band trust account interest rates, the 2020 present value of net resource rents would be 29.3 billion instead of 126.3 billion, of which the assumed share of the RST Anishinaabe would be $24.6 billion. They didn't do a calculation using the government long-term bond rate. But if they did, it would be slightly lower. When I say slightly, we're talking in billions of dollars here, of course, so I should be careful what I say, but it would be lower than the amount that we observe under the band trust account interest rates.
And in bullet 4, when you say of which the assumed share, you're still using the Stiglitz and Hutchings assumed share of 84.16.
Yes, I should have said that, Your Honor, you're right.
Thank you.
84% of 29.3 billion. So on slide 11, excuse me, you begin to address what you consider to be shortcomings in the Stiglitz-Hutchings approach. Can you talk us through those, please?
This is just a foretaste of what we're going to talk about, what I'm going to talk about in later slides, just so you know where we're going. These are concerns that I'm going to discuss as we go forward. The first one is that, in my opinion as an economist at least, NCRRs and not net resource rents are relevant for the augmentation clause promise. Obviously, I'll go into that in more detail later. Next, I'm going to suggest that net resource rents cannot in fact be fully taxed, so that they wouldn't be available for sharing, even if it were the right thing to be, concept of thing to be shared. They cannot be fully taxed. It's not feasible to fully tax them.
Is this a good time for me to ask a question? I'm asking this of both you, Mr. Marcello, and you, sir. Is this a good time to ask? And I do so with great humility, as we have learned to do in this trial. What you say is the relationship between taxation and the concept of rents. And from I come to the question simply the calculation of rents, as opposed to the, so I'll leave it at that, calculation of rents. And the reason I ask the question is it seems to me that a number of witnesses have focused on the problem of taxing rents. And at least once I asked the question, well, who's talking about taxing rents? This case is not about taxation policy. And it was possibly explained to me, as you have just now alluded to, that if the government is not collecting rents, then what do they have to share? But is there something else that you can tell me between maybe that's it, the relationship between taxation of rents and the manner in which they're calculated? And I started by asking you, is this the right time to ask that question, or do you address this at another time?
If I may, I don't think there's any wrong time for you to ask anything.
Okay.
In fact, that's a very good question, Your Honor. I wouldn't feel shy about that kind of a question at all. It's bits and pieces of the answer to that question will indeed come up later, but let me try and just very briefly address what you're saying. First of all, when we try to measure the taxation of resources for the purposes of this case, what we purposely do is focus on the extent to which taxes are paid on rents as opposed to something else. So that, and I think the plaintiff's experts, Mr. Hutchings, I think is in agreement with that. That what we're essentially trying to do is find out how much of when we talk about the net crown resource revenues, the resource revenues we're talking about are the portion of the rents that are collected as taxes or fees or royalties or stumpage by the government. That's one thing. That sort of leaves open the issue of, well, what determines the extent to which the Crown taxes rents? I mean, why don't they tax 100% of the rents? And that part of Professor Stiglitz and Mr. Hutchings' approach is to pose exactly that question. Why doesn't the Crown could tax 100% of the rents? Why don't they? If they could tax 100% of the rents, then we should think of the augmentation promise as applying to the potential rents that the Crown could have got rather than the ones they actually got through taxation. But that's not what we're doing. We're taking as given the tax rates that the government imposes on rents. When I say here that net resource rents cannot be fully taxed, I'm making a somewhat different statement. I'm making the statement that even if we accepted the argument of Professor Stiglitz and Mr. Hutchings that net resource rents are what are ultimately relevant for the augmentation clause, we couldn't feasibly tax those rents if we wanted to. It just would be too administratively, informationally, conceptually difficult to do so. So right away, we have to step back from the net resource rents concepts and talk about what is feasible to collect. So I don't know if that answers your question, but I'm just trying to draw this distinction between what we're doing, which is we're viewing net Crown resource revenues as the share of the net resource rents that the government actually collects, as opposed to what they could potentially collect, but for some reason didn't.
So, and I think I always understood that the focus then of measuring net Crown resource rent or resources,
Revenues, yes.
revenues, thank you, is an attempt to measure what the Crown actually collects. And that is the simple relationship between the concept or the relationship between the problems you point out with the taxation of rents and this case. You say, I believe, why measure something that is not collected? And leave aside the question of, and you have just given me some of the reasons. Leave aside the question of why those rents, while they might reflect value, are not measured.
Right. I agree.
You agree that I've
No,
got what you're saying? Is
Yeah,
that-
I agree that that's what you're saying. But I should also, I mean, when I come to the first critique of the Stiglitz and Hutchings, the essence of that critique is that what the stage one partial judgment and the Court of Appeal decision specified and the plaintiffs agreed to is that what is relevant is what the Crown actually collected as net resort revenues. It's not what they could potentially have collected. So that's sort of the distinction that I'm making. It's not that I think it's better or worse. I might, well, if I were coming at this, as a benevolent dictator or whatever, I might well think, but we should really be paying on the basis of what we could have collected than what we actually did. But I'm guided by the way I interpret what the previous judgments were. So, I'm sorry, that's an easy way out, but that's fine.
Even if the writers of either of those decisions, and I attribute nothing to any of them, never heard of rents at the time it was written.
Well, that's a good observation, Your Honor. I mean, they hadn't heard of rents, but rents is economist way of conceptualizing what it means to say, what is a natural resource revenue? What is a revenue that we can attribute to the natural resource per se, and not to anything else like the processing of that resource, the labor that went into produce it, that the concept of rent is an economic concept that is not in the partial one judgment or in the stage one judgment, partial judgment, sorry, or the Court of Appeal. Rents is an economic construct. And we have, as I'll talk about later on, we have no quarrel with the concept of net resource rents. Indeed, we accept it, as does Professor Hutchings. We regard the relevant tax, we try and determine what tax revenues to include in our calculation with reference to whether they are taxes on rents or not. And that's why this dispute about, should we include personal income taxes as part of the taxes on rents, and we argue, no, you shouldn't, because they're not taxes on resources. So,
Thank you. Thank you.
Very welcome. Your Honor, I'm going to suggest that the professor complete his discussion of this slide, and maybe then we take the morning break before we enter the primer on risk. Does that work?
Yes, thank you.
Let's continue, Professor.
okay, I'll try to be a little more efficient in my presentation. So I'm just going through a number of concerns that we have with the Stiglitz-Hutchings approach to augmentation. The next bullet simply says that net resource rents are difficult to measure and are significantly overestimated. That's a statement of an empirical statement about the way in which these net resource rents were measured by Professor Stiglitz and Mr. Hutchings. The next point is a little more subtle one, and I'll get into it in a little bit more detail, and that is that resource production in the RST territory spills over and affects production and rents elsewhere in Ontario. So from the point of view of the Crown, the net rents that result from resource production in the RST territory have to take account of the fact that they might have caused a spillover, a reduction in rents in some other part of Ontario. The next bullet is to argue that the joint venture's 84-16 approach to sharing is not persuasive. And the next bullet is that the 60-40 portfolio rates of return are not appropriate for bringing forward net resource rents to 2020. And the final bullet is that the income gap that they use to address the issue of relative wealth is not a reasonable estimate. So that's just a sort of a foretaste of the things that we're going to be going into shortly. So I guess the next slide is the next lecture, so we should probably take a break between lectures.
Very kind. Okay, so we'll take a morning break.
All right. Let's go recess for 15 minutes. Ms. Cohen, I assume you may be seated.
May we mark this deck as the next exhibit before I forget?
Or is it a lettered exhibit to start?
I think my friend's good with it being numbered. If he has any issues, he'll raise them as we go.
Yes, there's, I understand from my friend that the witness will be testifying to the matters in the slide deck. And so on that basis, I have no objection to it being marked as a numbered exhibit. And if there's any discrepancies, I'll raise it in cross-examination.
Thank you.
All right, Professor Boadway, let's talk about risk.
I just got kicked out of my system.
We start at slide 12, Your Honor.
Thank you. Go ahead.
If you would, begin your primer, please.
Okay. This shouldn't take too long. I thought it was quite important to be very explicit about what I mean by the cost of risk and different concepts of it. So I'm just going to run through a very primitive example of the interpretation of the cost of risk and use it to draw some implications. So if I can have the next.
Slide 13.
Yep. And the reason for doing that, as it says on this slide, is that the cost of risk is important in various aspects of estimating and using resource rents. And I focus on two in particular, one of them which is used by us and one of them which is used by the plaintiff's expert testimony, experts. The first is to adjust the value of NCRRs and or net resource rents for the cost of risk, for the fact that they are very uncertain and volatile. The second is in using a 60%, 40% portfolio rate of return, as is done by Professor Stiglitz and Mr. Hutchings in their two reports, includes a cost of risk in the rate of return to stocks. And part of what's at issue here is the extent to which including that cost of risk as part of the interest rate to bring forward NCRRs, net resource rents, is justified. So in order to help understand my position on these issues, let me go through the following simple example.
Can we
On
move to
page
slide 14 now?
14, yeah. This is a first-year undergraduate example.
Excellent.
In economics, not necessarily in literature. Suppose that you, I'm speaking to whoever's reading these slides, suppose you must choose between the two following options. You can either accept a coin toss, where if you toss a head, you get $2,000, and if you toss a tail, you get zero. So I'm confronting you with the possibility of undertaking that risky choice. This choice has an expected value of $1,000, which is just the average of $2,000, which is going to occur with a probability of 1/2, and zero, which will occur with a probability of 0. So this has an expected value of $1,000, but it's risky. It's risky in the sense that you could either get 2,000 or 0. And I'm going to ask you to make a choice between that coin toss with that kind of an outcome and a risk-free payment of some amount of money, which I'll call X dollars. Now, suppose that you will choose the coin toss as long as the risk-free payment is less than or equal to $800. So if the risk-free payment, if the risk-free payment is $900, you'll choose the risk-free option. But if the risk-free payment is $750, you'll choose the risky option.
You'll flip the coin.
Pardon?
You'll flip the coin.
You'll
to
flip the
700.
coin, yeah. Right. So I would say that that based on what you tell me X is, I would say that it is worth $200 to avoid the risk. So we can call that $200 the cost of risk in this situation. And in this situation, the cost of risk is 20% of the expected value of the coin toss. So the same principle can apply to something like the stock market. It can also apply to insurance markets, but let's think of the stock market. If the expected rate of return on stocks is 10%, and your cost of risk is 20% of the expected return, remember that these stocks, which have an expected rate of return of 10%, they could have higher or they could have lower, depending on the outcome. If your cost of risk is 20% of the expected return, you'll only invest in stocks as opposed to putting your money into a risk-free option if the risk-free rate of return is less than or equal to 8%. So if the risk-free rate of return is 9% and the expected rate of return on stocks is 10%, you're going to opt for the risk-free return. But if the risk-free return is less than 8%, you're going to opt for the equity. Now, we could make it more complicated and have you choosing a little bit of both, but let's sort of set that aside now to make the basic point. So we refer to this additional 2% that you have to get to invest in stocks as opposed to investing in the risk-free asset. We call that the equity risk premium. That's referred to in the literature as the equity risk premium. Now, the equity risk premium can differ among different people. It can be higher for some people and lower for others. In particular, sorry, professorial.
You needed Helen in your classes over all these years.
Good point.
Go ahead, the equity risk of
Okay,
return.
the equity risk premium in this example is 2%. And an important point to make is that this equity risk premium can be different for different people. And in particular, this will be relevant to our future discussion. The equity risk premium is likely to be higher for low-income persons than for high-income persons. In other words, the cost of taking a risk is higher for low-income persons than for low-income persons. And the reason for that, one reason for that is very simple. For a low-income person, especially a person who's at, say a subsistence level of income, the loss of income costs them a lot because they have to cut back on their subsistence expenditures and they don't have any accumulated wealth to draw on to tide them over a bad time. So their low-income persons are going to have higher costs of risk than high-income persons. Okay, that is just an explanation of the cost of risk. Let's move to the next slide if we're all ready.
Slide 15.
15. So an implication of this equity risk premium is that if you invest in stocks with an expected return of 10%, 2% of that is simply compensating you for the risk associated with investing in those stocks. It does not represent a net benefit. The net benefit you get from investing is the risk-free rate of return, 8% in our example. The additional 2% you get from investing in stocks is the compensation that you have to get to take the risk associated with investing in stocks. So in economics or in finance, we refer to that as a cost that you bear for assuming the risk. The implication is, if in this simple world, I'll get to a more complicated world in a minute, the implication is that the rate of interest for computing present values, the rate of interest at which you are willing to transfer money between now and in the future, invest money for the future, is the risk-free rate 8%. It's the net benefit you get from investing rather than consuming. It's true, if you put it into stocks, you'll get 10%. But that's not all, that doesn't represent a 10% worth of benefits, because 2% of that is just compensating you for the possibility that you might have a bad outcome. So we can refer to this 8% as this net benefit you get from investing rather than consuming, is sometimes referred to as the time value of money. If in addition, there are management fees or transaction fees associated with buying stocks, which there are in practice, that should be part of the equity premium. Okay, so that's the case. That's the first case I want to talk about. Now, if we're ready, we can go to the next slide.
I just have a clarification question, if I may, on the last bullet. It could well be me, it likely is me. You say there, if in addition, there's a management or transaction fee for buying stocks, which is the case in practice, that should also be part of the equity premium. Do you mean the equity risk premium,
Well,
or is this
I'm using
different?
the equity premium.
But-
People use interchangeably equity premium and equity risk premium.
Okay.
And the reason I'm calling it an equity premium here, it's the excess, it's the difference between the expected return on stocks and the risk-free rate of return. And that difference is partly a compensation for the risk of buying the stocks, but it can also be partly a compensation for the fact that you have to, there are some transactions fees or management fees associated with buying stocks. If they're zero, then they don't apply, but in general, they will be there. Okay, so slide 16.
Your Honor, are we good to move forward?
Yeah, let me know when it's a good time for me to ask the question, what calculations you think the average investor engages in? Could be not. Is this a good time?
You know, it's funny, in economics, we think of ourselves as sort of social scientists, and we just observe the way people behave, and we sort of infer from that they've thought about why they did what they did. It's not a simple question you're asking. It's a question about behavior. I mean, I would certainly say in general that when people do risky things, they're aware of the possibilities that things are going to go awry, which is why they buy insurance. Buying insurance is the opposite side of it. It's avoiding risk by paying somebody else to take on the risk, okay, which actually is going to be important when we come to talk about annuities. But that's not a very good answer. That's not a very good answer to your question, my honor, but that's
But the reason I ask this question, obviously, is because it seems to be based on an assumption that the parties in this case would have engaged in these calculations. Happily, you say they're just at the undergrad level, but I would say some of the assumptions that we have heard so far in this case might have verged closer to the graduate level of assessing risk.
Mhm.
And if economics is more than the study of the psychology or the behavior of individuals, when is it more than? Like, do you name the point at which these calculations, which you can make and which an economist can make to determine the cost of risk
Mhm.
are actually used by investors, and particularly the potential investors in this case? I mean, maybe that's just a way bigger question than you're.
No,
Not
it's
contemplated.
it's a good question. I mean, the investors in this case, they can be the crown. The crown can be the crown we're talking about, who's getting all of these
Mhm.
NCRRs and then trying to evaluate them. And there's a risk to them of not, that the net resource rents or the NCRRs can be high or low in any given year. And it's costly to them to have this fluctuating revenue stream. Individual investors, I mean, people are going to have different attitudes towards risk. So we can't say that the equity premium is the same that applies to everybody. But it's nonetheless the case that if people didn't put a cost of some implicit cost on risk, then they would always purchase the asset that has the highest expected return. They wouldn't buy any risk-free returns, because if they don't care about risk, they would just buy risk-free returns. They wouldn't buy insurance for their house. Well, they might be obliged by the law to buy car insurance, but most people would buy insurance against accidents of some sort or another, because it's costly for them to face the risk of such an accident. So people do care about risk. And the best estimate we have of how much they care about risk is the difference that you observe in practice between the expected return on a risky asset or venture or whatever, and the expected return on a non-risky venture.
And you obviously, this being the primer, you obviously return to these concepts later on.
Yes.
You will. So let's go then to, if we may, Your Honor, to the
Thank you.
long run cost of risk.
Okay, so now this one's
slide
actually
16.
important because it sort of goes in the direction that the Stiglitz and Hutchings RST report goes in conceptually in any case. Suppose instead of you just being confronted with flipping a coin and getting 1,000 or 2,000 or zero, or getting some fixed amount of money, you get to do this coin toss repeatedly. You're confronted with a situation where you can just repeatedly toss a coin over and over again. Each time you toss it, you either get 2,000 or zero. Each time you toss it, it's a separate event. If you think about it, in some periods you're going to get heads, and other periods you're going to get tails. So that over a period of time, some part of the tails are going to be offset by the heads. So it may be that if you've done this 20 times, you aren't certain what you're going to get, but you know that the average of what you're going to get over those 20 coin tosses, the average of what you're going to get is going to be somewhere between 2,000 and zero. But it's still going to be a little bit risky to you. But if you can conceptually imagine doing this coin toss repeatedly, an indefinite number of times, over and over and over again, the law of averages will say that the average income, the average outcome you're going to get, the expected outcome that you're going to get when you average it over a very large number of coin toss is going to be $1,000. So in those circumstances, if what we're confronting you with is the possibility of doing this repeated coin toss over and over again, the expected value of that is going to be $1,000, and there's not going to be any risk involved, because all the risk is going to be pooled over time. So you're definitely going to take that series of coin tosses over a series of $800 payments instead. Now, I don't know how many people can imagine this, but this is kind of what is going on when Stiglitz and Hutchins RST report talks about investing for the long term, creating a sovereign wealth fund, creating a pension fund. This is what's going on. This is how the cost of risk is reduced, because you can do this pooling over a period of time. I don't know if that's clear, but it's my attempt to distinguish between when you have to worry about the risk premium and when you don't. And it's absolutely germane to our interpretation or critique of the Stiglitz-Hutchins discount rate. Okay.
So let's go to the implications then, slide 17.
Okay. So this just draws out a little bit of what I was saying already. Suppose you have a given amount of wealth to invest. If you invest it over and over again, but keep it intact, the average return you will get will be the expected return on the risky stocks after a long period of time, and you will have virtually eliminated risk. There will be good years and bad years, but holding this bit of wealth in this stock for a long, in this fund for a long period of time allows you to pool the good years against the bad years, and on average earn the expected rate of return. You can take the interest out every year that you earn, but you must keep the principal intact. This is how a sovereign wealth fund works. This is precisely how the sort of model sovereign wealth fund that people always talk about, the Norwegian one, which Professor Stiglitz and Mr. Hutchins talk about. This is how it works. They invest all of the resource wealth and they leave it there for a long, long period of time, and they only use the interest that they get on this wealth. And in the process of doing that, they can get a high return and have relatively low risk. So that's just to make that point. That corresponds with the Stiglitz-Hutchins RST reply report, hypothetical argument for ignoring risk and using the 60-40 portfolio return as if it were risk-free. Professor Stiglitz and Mr. Hutchins expressly say that the rationale for using the 60-40 portfolio return approach and ignoring risk is because the Anishinaabe could have invested their annuities into either a sovereign wealth fund for the long term or a pension fund for the long term. So that's why I'm going through this exercise.
Slide 18.
This simply repeats what I had said earlier, so I won't spend too much time on it, but it just says that this cost of risk arises in this action in two different ways. One way is because if you accept one of the approaches to sharing of Professor Smart and myself, that is to risk adjust future expected values of NCRRs to account for the fact that viewed from the perspective of 1850s, NCRRs are uncertain. This is one approach to setting the share of NCRRs used to determine annuities. I won't go into the small print there because it repeats essentially what Professor Smart said in his testimony, explained in this testimony, that this procedure of risk adjustment is a very standard, just referred to as the standard asset pricing principle in the Stiglitz-Hutchins report. The other way in which the risk premium arises is in the market portfolio rate of return. The market portfolio rate of return on stocks equals the interest rate plus the equity risk premium. And our position is that this equity risk premium is compensation to the shareholder for the risk associated with the return on stocks, and that the net return to the shareholder is a risk-free rate of return. So I'm going to come back to this when I talk about the 60-40 approach in the Stiglitz-Hutchins.
Let me just catch up for 1 second, please. sorry, you said if you accept one of the approaches to sharing, whose approach is that? That's your proposal?
Yes, one of the
Okay.
approaches, one of our approaches to sharing is risk adjustment as a way of determining the amount of NCRRs to be shared.
And that approach is you account for NCRRs in an account, but government pays out interest only.
No, that's not,
Oh, sorry.
that's not our argument. No, our argument is that there's no sovereign wealth fund associated with risk. NCRs come in annually
Yes,
as a stream, and they're very, very volatile up and down. That stream has risk to the government. And we're evaluating that risky stream of NCRRs in a way which is analogous to evaluating a risky asset using something called the asset pricing approach that Stiglitz and Hutchins refer to.
thank you.
So let's go to slide 19, part 3,
Okay,
please.
so I'm now starting on the remainder of my,
Just, if you could just hold for a moment, is there
No,
a
go
problem
ahead.
getting it up here on the screen? Is we just got a little message saying there was a problem. Okay. All right,
okay, so now I'm going to proceed to go through the remaining whatever, there are 5 bullets on the original outline that I proposed. The first of them is the relevance of net resource rents for the RST augmentation promise. I'm sure this is something that's come up before, but I'll go through it in any case because it's part and parcel of our response to the Stiglitz-Hutchins RST report. So if we go to slide number 20. Slide number 20 provocatively says that net resource rents are not NCRRs. Well, we know that. But why am I saying that? I'm saying that because to an economist, a reading of the Court of Appeal decision, or the part 1, partial judgment for that matter, suggests that NCRRs, not net resource rents, are relevant for fulfilling the augmentation promise. And I've put a quotation there that would be well known to everybody, which comes from the Court of Appeal decision. And I've highlighted part of it. And the part I've highlighted says that the parties, by the parties, it means the parties to the dispute, were in agreement that the revenues that are to be taken into account in determining whether the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss are net crown revenues from the territory. So I've simply highlighted that to make a point that's well known to everybody that the Court of Appeal decision following on the stage 1 partial judgment made this statement that, and which was agreed to in advance of the trial by the parties. Next slide.
21.
Slide 21 just carries on and elaborates a little bit on this point to emphasize why it's our position that NCRRs are what should be taken into account in judging the augmentation clause. Pursuant to the Robinson Superior Treaty of 1850, the Crown is obligated to increase, and the First Nation treaty parties have a collective treaty right to have increased from time to time the promised annuity payment of £5,000 or $2,000. And I emphasize this, if net Crown resource-based revenues from the treaty territory permit the Crown to do so without incurring loss. So that's sort of, in addition to emphasizing that what's at stake here with the augmentation clause are net Crown resource-based revenues. I would infer that that's also suggesting that the term without incurring loss I'm not saying this as a lawyer, and obviously you may have a different opinion on this, but the way I read that judging whether or not the Crown is incurring a loss is based on whether net resource-based revenues are showing a profit or a loss. I haven't put that in a very elegant way, but without incurring loss, I'm suggesting is a statement that's made with respect to the net Crown resource-based revenues that are generated from the treaty territory. In other words, the Crown would only be obliged to pay out augmented annuities if the net Crown resource revenues that they had obtained from the territory permitted to do so without drawing on other revenues. And then finally, from the stage one reasons for decision, the plaintiffs have argued vigorously and successfully that the treaties were relational agreements that incorporated the concept of sharing the benefits of the land. And again, my emphasis, sharing by definition does not include taking 100% of the net benefits from the Crown. And although it's a bit, what the term net benefits means in this context, I would take it that net benefits refers to net Crown resource revenues, NCRRs. Okay. That's an economics person looking at these statements, and not a lawyer. If we turn to the next slide.
Slide 22, implications.
So just to repeat, in my view as an economist, these quotes suggest that NCRRs and not net resource rents are the appropriate metric for determining the amount to be shared under the RST augmentation promise. In contrast, the estimates in the Stiglitz-Hutchings RST report and reply report are of the value of land and resources and are not limited to NCRRs. So they don't have relevance for this determination. The determination in the previous point.
Slide 23. We go back to Professor Stiglitz and Hutchins.
So it's useful to recall what Professor Stiglitz and Mr. Hutchings stated in their reports and reply reports. First of all, reading from the Stiglitz-Hutchings main RST report, the appropriate economic framework for assessing a sharing of resources is a joint venture style relationship. Under that framework, on an ex-ante basis, at least 84% of the wealth of the RST territory would accrue to the RST Anishinaabe. That's in their main report, that their version is that 84% of the present value of net resource rent revenues would accrue to the RST Anishinaabe as part of the augmentation promise. Further, they state in their reply report, rather economic rents are a measure of the economic value attributable to the natural resources that make up the Anishinaabek's contribution under the treaties and are thus the appropriate benchmark for determining fair compensation, regardless of the extent to which the Crown opted to collect them as direct resource revenues or opted to subsidize settlers in pursuit of other objectives. That simply emphasizes the point that their interpretation is that net resource revenues are the relevant metric for determining the sharing in the context of the augmentation promise. I would just note down as a third bullet that if we look at Mr. Hutchings' RST report, the argument that net resource rents are the benchmark for determining the amount of revenues to be shared is contradicted by the Hutchings RST report, which uses NCRRs for that purpose. Mr. Hutchings says in one place that the augmentation clause requires that 84% of net resource revenues of NCRRs would satisfy the augmentation promise. But elsewhere with Professor Stiglitz, he says that 84% of net resource revenues, which is total resource revenues less cost, should be shared with the RST and Anishinaabe. Those numbers are very, very different.
So could we just hold for a moment and let Her Honor catch up, please? Thank you. Let's go to slide 24, Professor. I'm sorry. Yes, slide 24.
So this is just a little bit of a discourse on net resource rents, Your Honor, related to a question you raised earlier about taxation and net resource rents. And this is meant to be to represent our view of net resource rents. When I say ours, I mean myself and Professor Smart. The present value of net resource rents as defined by the plaintiff's experts is an appropriate measure of the value of resources, subject to all the problems of measurement and so on that we're going to confront later on. But we perfectly well accept this notion of net resource rents as being an appropriate measure of the value of resources. Net resource rents are the product of resource production. They don't come with the resource themselves. Just because we acquire some territory full of trees or a land which has got minerals underneath it, the rents are not there to be taken. The rents can only be achieved by production of the resources. They require labor, capital, knowledge, information, and enforcement of property rights, some of which are provided by the Crown. So it's not as if the Crown, when they're acquiring the territory, is acquiring rents. It's acquiring the potential for generating rents through resource production activities. The next bullet is one that I think we talked about before, and that I think is agreed by the experts for the plaintiffs, and that is that revenues generated by resource processing are not resource rents. They're revenues that are attributable to the labor and capital and other inputs that are responsible for the processing. Our estimates of NCRRs are based on the concept of net resource rents. Net resource rents are NCRRs are the portion of net resource rents that the Crown obtains through taxation, fees, and the sale of resources. So the challenge that this imposes is to be sure that in measuring NCRRs, we're properly taking into account the revenue sources of the Crown that actually came out of the pool of net resource rents that were produced in Ontario.
The measurement of the NCRRs, you say, is that is the revenue sources that the Crown actually came out of, the revenue sources to the Crown, maybe, that actually came out of the pool of the rents that were produced in Ontario.
Conceptually, that's what we're trying to measure when we measure NCRRs. Yes, Your Honor. So
Isn't-
we, that this has some substance to it, the statement you just made. It defines what kinds of revenues we view are legitimate components of NCRRs. And there's no dispute with Mr. Hutchings on this, I don't think. There may be disputes about how we actually do the measurement, but the idea is that the revenues that we want to include in NCRRs are the revenues that come from the rents of those resources, not from somewhere else.
I thought from time to time, the debate was not so much what revenues come into the Crown's hands, which is that taxation issue, but when to stop counting the revenues. Isn't the rent approach that you look at the revenues downstream from the actual resource extraction? And that there are revenues downstream that are attributable to the resources? Isn't that the debate? It's not so much whether there are revenues, but at what point are the revenues, you say, relevant? And that has been the word amongst the economists. These revenues are relevant. These revenues are not relevant. In addition to the argument, these revenues are not collectible, or they are collectible. But let's go to the relevant one, because that's where we are in your slide.
Yes, I agree with what you're saying, Your Honor. Let me just add one nuance to it.
Okay.
I hate to do that, but it's true that the revenues that are generated from resources do not accrue at the same time as the production or the expenditures on producing those rents accrue. And I think part of the point of the debate in previous testimony had to do with what expenses to attribute to those revenues, as opposed to what revenues to attribute to those expenses. So for example, one of the things that we include as a resource related expense is reforestation, to take an example. And reforestation, we're talking about a renewable resource. So when the forest is exploited, trees are cut down, that's the use of, that's sort of like the use of capital. You have to replenish it. And so the argument is that when you rehabilitate the trees in the forest, you're simply replacing trees that had been used in producing rents. And it's legitimate to incorporate that as a cost of producing the revenues, because it's a cost of replacing the trees that were cut down in order to generate the revenues. Now that cost occurs after the trees are cut down, obviously, because it's only after the trees are cut down that you have to redo the reforestation. But Professor Smart and myself would attribute the cost of reforestation as being a legitimate expense of producing the resource rents from the forest. And the same would apply to mine, whatever the equivalent word is for mine rehabilitation. When you clean up old mines, you're essentially incurring a cost. You're doing something which was a cost incurred as a consequence of extracting ore from the mine. So that mine site rehabilitation, I guess you could call it, is also a legitimate cost of generating mining rents. I'm not sure if that's what you were asking, Your Honor.
No, I was talking about the downstream processes.
Okay.
And for instance, if we take timber revenue, the downstream processes of milling, pulp and paper, and whatever else is downstream, that those, my understanding is that Stiglitz-Hutching approach, or the way they conceive of rents, is that the revenue from those processes are attributable to the natural resources. And that the debate is when on that downstream process, or when, starting with the first axe in a tree,
Mhm.
when do you stop counting revenues? You
Mhm.
stop counting revenues once the stumpage fees are paid, or once that the product of that piece of timber has gone to market
Mhm.
in whatever manner it's been processed. And Professor Smart said, we attribute whatever happens after the logs are collected to a manufacturing process. We don't attribute that to a resource revenue.
Yes. Yes, oh, I'm sorry, I misinterpreted your question. You're absolutely right. Our position, and I thought it was the position of Professor Stiglitz and Mr. Hutchings as well, our position is that downstream processing, let's call it,
Mhm.
is separate from the value of the resource itself. You extract the resource, the rent that you get is reflected in the value of the resource when it's extracted. If you then do further processing, further processing involves adding more labor, capital, electricity, or whatever it might be, to enhance the value of the ore. That would not be, and I think this is consistent with what Professor Stiglitz actually would say, that would not be part, the income from processing would not be part of the rent of the resource. The resource rent is just the value of the resource, of the raw resource after it's been extracted.
Okay, thank you.
So now on slide 25, you address the three-step procedure, you call it, for augmentation, consistent with the Court of Appeal decision.
Okay, this is just put in here again for kind of context of where we're going. And I won't spend much time on just sort of proposing that this is the approach we take to dealing with the augmentation clause that we think is consistent with the Court of Appeal decision. The first is to estimate NCRRs and their 2020 present value as the amount available for sharing. So you can think of that as the size of the pie. I'm trying to make a distinction here between what's to be shared and what are the shares that you would apply to that. So the first thing is to determine what's to be shared. The second thing is determine how to share that pie, taking account as appropriate of wealth and needs of the RST and Anishinaabeg relative to other communities in Ontario. Some sharing concept based on either the approach we take or the approach Mr. Stiglitz and Professor Stiglitz, Mr. Hutchings take. And also taking account of the cost of risk from the uncertain and volatile stream of NCRRs, which is largely borne by the Crown. And then the third step, in our view, would be to convert this volatile share of NCRRs attributable to the RST Anishinaabeg, but it would be volatile, into a smooth stream of augmented annuities. And in so doing, ensure that the augmentation does not cause the Crown to incur a loss, which would violate the terms of the treaty.
I have one question before we move on to the next slide, but I'll wait for her on it.
This is a very simple question. Is it possible that I understood Professor Smart to focus on the, or when he focused on this volatile stream, that he focused on this burden as something borne by the annuitants
Well, I think his point was that if you gave a share of NCRRs to the annuitants, they would be faced with a volatile stream of with volatile stream, and they would bear the cost of risk. And the cost of risk to the annuitants is much higher than it is to the Crown, as Professor Stiglitz and Mr. Hutchings actually note in their report.
Okay, is that a different view then, when you say, which is largely borne by the Crown? You say it's a higher risk for the Anishinaabe, but then you just say it's largely
My
borne
wording
by the
is
Crown.
perhaps not as clear as it should be there. Your
Okay.
Honor. My view is that, I mean, I guess I'm getting a little bit ahead of myself here. I'm suggesting that the Crown should bear more of the risk because they're better able to bear the risk than the Anishinaabe. And we should find a way of satisfying the augmentation clause that takes as much risk away from the Anishinaabe and gives it to the Crown. And that would be efficient because the Anishinaabe have much more difficulty, would have much more difficulty in our view, adapting to the risk than the Crown would.
So the second bullet under number 2, sharing based on bargaining or joint venture approach. I just want to understand where the yellow line is drawn here. The bargaining approach is the one that you and Professor Smart suggest is appropriate here, and the joint venture is the one Professor Stiglitz and Hutchings support. Is that?
Yeah, I in practice, Professor Stiglitz and Mr. Hutchings point out that you could have either a bargaining approach or a joint venture, and they're going to opt for the joint venture approach
As their preferred.
as their preferred approach. And we're going to say that that's not appropriate, that it's more appropriate to take a bargaining approach, but the nature of the bargain is going to be different than the nature of the bargain that they talked about. And it's going to be more akin to the bargaining that you might observe in wage negotiation, where one side takes all of the risk of the profits varying and the other side is sort of given a fixed wage package. And we're sort of, part of what we're saying is that you can have a bargain, which is a bargain that generates not just a share of NCRRs, but also a scheme whereby the risk associated with the sharing is borne more by the Crown than by the Anishinaabe. And that's one of the reasons why we've proposed this annuity scheme, whose name I won't mention.
Thank you.
Did you watch RST TV last week?
So I think you'd made all the points on this slide. Am I correct?
Yes,
Let's go on then to slide 26 to your conclusions.
this is just a summing up of this first bullet of this. I guess it's the third bullet point that I've been dealing with. Conclusions on why the Boadway SMART reports use NCRRs and not net resource rents. The first bullet simply recounts that the Stiglitz-Hutchings RST report principally measures the value of land and resources in the RST territory using the concept of net resource rents. And they use these net resource rents as the amount, they explicitly treat them as the amount to be shared between the Crown and the RST Anishinaabe. The Court of Appeal stated that NCRRs constitute the amount to be taken into account in determining augmentation payable to the RST Anishinaabe. And finally, and not an important point, which also has a bearing on why I put those quotes from the Court of Appeal decision earlier on, the RST Anishinaabe share of net resource rents proposed by Professor Stiglitz and Mr. Hutchings would exceed the value of NCRRs. So would entail the Crown incurring a loss, which in our view would be contrary to the RST, the treaty. And this is a point that will come up again.
The math on that appears later. Now, if we go to the next section, on slide 27, section 4, difficulties in measuring and taxing net resource rents. Let me set this up if I may, and if I'm wrong, you'll correct me. But you've made the principal point, it appears that rents are not the appropriate metric, but that net crown resource revenues are. But here you go into a section where you say kind of, well, even if rents were the appropriate metric, here are some difficulties.
You have exactly right. Yes.
Okay, so let's go through that then if we could, please.
And there may be other reasons why you're interested in net resource rents besides determining what's to be shared.
Let's go then with slide
So the
28.
purpose of this section, this would be my section number 4, I guess. Besides taking issue with the relevance of net resource rents for the purpose of fulfilling the RST augmentation promise, it is worth recounting the various problems with Professor Stiglitz and Mr. Hutchings' estimates of net resource rents in the RST territory. So that's the purpose of this section. If you're not interested in net resource rents, this is probably gratuitous, but anyway, we'll go through it.
May we begin at slide
Yes.
29, would it be?
I want to make a point here that, again, has to do with the concept of net resource rents. And I don't know why I put this, I don't know really why I put this slide on here, but I think it's a point that was raised in discussing with other people. And it's a distinction between resource rents, actual resource rents that come about from the actual pattern of production, resource production, versus potential resource rents that could have been achieved according to some other pattern of resource production. And I'm simply making the point that potential resource rents are those that could have been obtained in the territory had optimal investments been made in exploration, development, and extraction, or harvesting with no wasteful production. Sounds like a bit of an obvious point. But in contrast, actual resource rents are those that are actually obtained, given the resource investments that were undertaken and the rate of extraction or harvesting that were part of that process. And the point is that actual resource rents may not be optimal. For example, extraction might be too rapid. We may cut down trees too fast. We may extract minerals too fast. There are entire resource economic theories that have to do with the optimal rate of extraction of renewable and non-renewable natural resources. Professor Stiglitz and Mr. Hutchings estimate actual net resource rents, not rents that could have been obtained with optimal investment. I'm not necessarily criticizing on this. I'm just sort of pointing out a conceptual point that estimating potential resource rents would be difficult, but arguably it is a more accurate reflection of the value of the land and resources associated with the RST territory. So if someone really did believe that net resource rents were the thing that we should be bargaining over, they should be thinking in terms of potential resource rents, not the ones that were actually achieved by the patterns of production that took place over the 19th and 20th centuries and 21st century. So I'm not sure that slide has very much value added to the debate, but it just
Well,
background.
from actual resource rents, am I correct that net crown resources themselves are something different?
Yes.
And you went through that 40 minutes ago or so.
Yes.
So let's move on to slide 30, please.
Okay, so now we get into the nub of the approach that Professor Stiglitz and Mr. Hutchings make about estimating net resource rents in the treaty territory. And the first question I pose is, could the Crown tax or have taxed 100% of net resource rents. Professor Stiglitz and Mr. Hutchings say emphatically yes. And to quote them, an efficient revenue collection system would have the Crown appropriate all economic rents in the form of well-designed land and resource sale policies and rent taxes. That comes from their main RST report. Or elsewhere, they say, the Crown could have collected all the economic rents and then distributed part of the proceeds back to those who the Crown granted access to the resources at below a competitive level. So the point is, their position is that the Crown, if it wanted to, could have taxed 100% of the net resource rents. The reason they didn't must have been for some other reason, some of which they talk about. We disagree. The Crown could not have taxed 100%, could not tax or have taxed 100% of the rents. And so I'm going to explain why I take that view in the next few slides.
So we go to slide 31.
We're being sabotaged.
31.
Here we go.
Yeah.
So why is it our view that the Crown could not tax 100% of net resource rents in the RST territory? And I've set out 4 general arguments, which I'll talk a little bit about in the following slides. The first one is that the resources that are being exploited in the territory are being exploited by private firms. Private firms know what their costs of production are and what the revenues that they obtain from the rents are. The government doesn't. The government has limited information about the value of resource rents obtained by private producers. Secondly, there are some conceptual difficulties in measuring resource rents, which are very difficult to overcome, and I'll talk about those. Third, the avoidance and evasion of resource taxes by private producers and the need for costly enforcement constrain the ability to impose 100% taxes. And fourthly, which I think is important, and it sort of bears upon this, the same argument about avoidance and evasion and so on. The tax rates that apply on resources in Ontario apply province-wide. They don't just apply in the RST territory, they apply in all other areas of the province. It would not be feasible to impose a tax on resource rents specifically in the RST territory. It would not be feasible to administer it. So I'm going to elaborate a little bit on some of these points in the coming slides.
Your Honor.
Go ahead.
32, slide 32.
Let me begin with the observation that the Crown may lack information on the cost of resource production by private firms. And I'll draw a simple example from our present value report to illustrate this. Suppose we have a hypothetical example of 2 mines. We have a low cost mine that sells $10 $10 million worth of ore and earns resource rents of $3 million. The other $7 million constitute the cost of extracting the ore. We also have a high cost mine that has the same revenues of $10 million and earns resource rents of only $1 million because it costs $9 million to extract ore in that case. Professor Stiglitz and Mr. Hutchings would propose a $3 million tax on the first mine and a $1 million tax on the second, and these would collect 100% of the rents. We all agree on that. Such a scheme would be efficient. It wouldn't affect production or investment. However, in order to impose such a
Sorry,
scheme,
what did you say on bullet 3?
such a scheme would not affect production and investment. It
Thank
would
you.
be efficient. I was
Thank
just using a term for not affecting production and investment.
Thank you.
Sorry, it's my economics. However, in order to impose this 100% rent tax, the Crown would have to observe resource rents from each mine, which in turn requires that the Crown observes both the revenues and the costs of production, or somehow obtains that information. And typically, it doesn't observe it. It's given that information by the firm when it files its mining tax forms. Next slide.
Slide 33.
Now, in that simple example, what happens if the Crown cannot observe the costs of production? Well, in that case, it must impose the same tax on both mines. This is obviously a bit of a contrived example to make a point, but it's a point that is applicable whenever the government can't perfectly observe the costs of mines, and you have mines with different productivity. The government, in this simple example, might impose a $3 million tax on both the high cost firm and the low cost firm. If it does so, it will cause the high cost firm to shut down, since the high cost firm has costs of has rents of only $1 million and couldn't pay the $3 million tax without losing money. Or it might impose a $1 million tax on both and forego the full taxation of rents on the low tax firm. So this is one situation where the government couldn't impose 100% tax on rents. Now, as I said, the Crown relies on information provided by the resource companies themselves. It has the option to go out and check this information by inspecting, auditing the financial statements to obtain information. But no matter how hard they do that, private companies are somehow able, with the assistance of clever lawyers, I must say, to either hide the full costs of production, or either by tax avoidance, which is perfectly lawful, or by tax evasion, which is not. So it's practically difficult to know for certain what the costs are of resource producing companies.
Slide 34.
And the same thing applies on the revenue side. Or in some sense, on the revenue side, it applies with more complications. So just let me mention why that's the case. One of the problems, and this goes back to the comment that Your Honor made a little earlier on about extracting the resources and processing them. In many cases, mining firms and timber firms as well may both extract resources or harvest them and process them. In fact, it's more common than not that mining firms will do some processing of the resource before they send it off to the market. But resource rents, what we want to include as resource rents, do not include processing profits. They only include profits attributable to the resource itself. And it's practically very difficult to separate out the profits of a firm that both processes and extracts resources into those profits that are attributable to extraction and those that are attributable to processing. So there are information costs that prevent the Crown from imposing a tax that applies only to resource rents. Furthermore, this is made more difficult by the fact that some of these resource firms might be international firms or even interprovincial firms who sell their ore for process to another branch of the firm that's operating in a different jurisdiction, and that might face different tax rates. And in those circumstances, the resource firm can engage in what's referred to as transfer pricing that you might be familiar with. So for example, a large multinational firm, to take a case, an example might extract resources in the RST territory, take those resources abroad for processing, and misreport the value of the resources to the Ontario government when they were sending in their tax form for the mining profit tax. That is to say, they can decide to report to the government, well, the actual price that we're charging ourselves for the ore that we're getting from our own firm is not, X dollars per ton, but it's X minus Y dollars per ton, where they're going to underreport the price that they get for the ore they extract in Ontario. This is referred to as transfer pricing. That's a very big, very important, very intractable issue in international taxation. And it's also a challenge for the taxation of profits on resource producing firms. This particular challenge was noted by the Royal Ontario Nickel Commission report of 1917 that Mr. Smart referred to in his testimony. Moreover, firms that operate in more than one jurisdiction can avoid taxes perfectly legally by their choice of country location for doing, for example, the processing in, or for doing their initial mine development in. They can sort of say to Ontario, well, we're not going to develop this chromium mine in Ontario because if we develop it in Peru, we're going to get a much better tax bill. So these multinational firms are faced with what's called tax competition. And the existence of tax competition constrains the Ontario government from imposing 100% tax on resource rents, because if they do so, the firms that are making these production choices may well move to another jurisdiction where the tax on resource rents is less than 100%. And this is a well-known problem of tax competition, which it has been documented to influence mining tax policy in Ontario. There's a reference to a book by Viv Nellis on this in our response report. This is just one more sort of element of problem associated with having 100% mining tax.
You refer to the Alaska oil situation on the next slide,
Slide 35.
slide 35.
Okay, I put this slide up, not to be nasty or anything like that, but just to note that, well, I knew this already, that the experts on the other side are perfectly well with information problems. One of the experts on the other side won a Nobel Prize for his work on imperfect information, so it's not surprising that he would be aware of this. But you know, we found some work that Professor Stiglitz had written on the design of a rent tax on oil in Alaska. And to quote from this article, by overestimating their costs by just a few pennies per gallon, the oil companies would increase their profits enormously. They also found other ways to cheat, such as selling oil to their subsidiaries, reporting a lower than fair market value, and reporting a fictionally high shipping cost. That's nothing other than what I've called transfer pricing. I'm sure Professor Stiglitz is perfectly well aware of this.
Now on slide 36, you begin to introduce the concept of enforcement. Am I right?
Yes.
Let's go through that, please.
This is a little bit related to the comments I made about tax avoidance, tax evasion earlier on, that you know the way our tax system works, as you well know, just going past this time of year, is it's a self-reporting system. Taxpayers report their incomes. Firms report their revenues and their costs to the taxpayer. The taxpayer takes that information and assesses a tax, and that could be the end of the story. However, the tax authority, the Canada Revenue Agency, or the Ontario Tax Collecting Authority, in the case of the mining tax, has to worry about the fact that some firms might misreport their revenues or their expenses. And so they have a vast machinery for enforcement, which includes auditing of suspicious returns or random auditing and so forth, and punishing firms that are determined to have reported imperfectly. But enforcement is costly. You can't check up on every taxpayer, and it's also very imperfect. You can't be sure that the auditing that the tax authority does is going to detect all of the instances of avoidance. And moreover, what counts as tax avoidance is sometimes difficult to discern. It's not really easy to write a tax law in such a way that the concept of tax avoidance is unambiguous. There's always some interpretation that has to be made. And the consequence then is that enforcement is not only costly, but it's also imperfect.
Sorry, I was confused. Did you mean tax evasion or did I just misunderstand? What
I
what
meant
is
tax avoidance.
tax avoidance
Yeah.
is addressed in government
Yeah.
statutes?
Yes.
Okay.
Yeah. Sorry. I mean, what I'm saying is even setting aside the possibility that some taxpayers may be involved in outright evasion, illegal reporting. Others may be involved in avoidance, which is sometimes hard to define. They may believe they're behaving properly, but it's a matter that's not very, very well articulated and it can't be well articulated in tax law. So the point is that you combine this with the fact that the higher the rent tax you impose, the more this encourages avoidance and evasion. And the reason is because the higher is the rent tax, the more you have to gain by misreporting your profits. So avoidance and or evasion activities rise with higher rent taxes. So what we're faced with is the fact that the higher rent taxes encourage avoidance and evasion, which means that the government has to put more resources into enforcement to making sure that the tax law is abided by. So there is what economists would refer to as a trade-off between costly enforcement and high rent taxes. If the government wants to have high rent taxes, they have to have costly enforcement to ensure that those rent taxes are actually paid. This trade-off is going to have the implication that rent taxes are inevitably going to be less than 100%, because if they were 100%, they would encourage avoidance and evasion, which would
Are you suggesting there's some sort of if I could call it that, some sort of a sweet spot?
Yeah, that's exactly the street interpretation of a trade-off. Yes. Yeah.
Obviously, sweet spot is not the street language.
Depends by
I
street. Yeah.
think we've learned.
So this is all part and parcel of the discussion about why taxes can't be 100%, why rent taxes can't be 100%.
There seems to be one more slide in this area, one more area, sub area to address here, Your Honor, and then we move into a different conceptual area. It's 1 o'clock. Did you want to finish this one slide and take the break, or whatever everybody wants to do?
Yes, please.
Okay, so let's finish slide 37, please.
This won't take very long. I'm just quoting a statement from Para 104 of the Stiglitz and Hutchings RST report to the effect that that rent tax revenues could be higher with a different tax system. They say that the rents associated with the Anishinaabeg's land and resources could easily have been calculated and captured with an efficient collection system and shared with the Anishinaabe. Subsequent to that statement, they really don't provide any examples or evidence how that could be achieved.
Thank you.
You take the lunch break. And I just have lunch break. I just have one question, Council, before we leave.